Welcome to the deep dive. Today, we're really wrestling with maybe the toughest challenge in negligence law, proving breach, when the direct evidence just isn't there.
It's a huge hurdle.
Right. The plaintiff has the burden. They've got to prove all 5 elements: duty, breach, cause, in fact, proximate cause, and damages. And it's by a preponderance of the evidence.
Yep.
So our mission today is to figure out the legal paths plaintiffs take when all they really have is an injury, but no smoking gun.
That procedural barrier is massive. And the core principle, always remember, is that just because an accident happened, well, that's never enough.
Never enough.
The jury has to find it's more likely than not the defendant acted unreasonably. If the evidence isn't there, the plaintiff just loses.
So how do they bridge that gap?
Well, we have to look past direct evidence, eyewitnesses, video footage, and dive into these specialized circumstantial doctrines. These are the tools.
Okay, let's unpack those tools. We have 2 main ones to analyze today, right? What are they, and maybe how do they differ in what they let the jury infer?
Exactly. We're focusing on 2 really powerful but very structured circumstantial frameworks. First up is constructive notice. That one's all about inferring duration, like how long a hazard was actually sitting there.
Okay, jury.
Second, we tackle res ipsa loquitur, RIL for short. This one's different. It focuses on inferring the fact of negligence itself. That negligence must have happened, even if we don't know exactly what went wrong. So our goal here is to really model the rigorous, step-by-step analysis courts demand before you can even use these rules.
All right, let's start with the basics then. Circumstantial proof. Direct evidence, like you said, video, eyewitness, requires no inference. It is what it is.
Right.
But circumstantial evidence. Now we're asking the jury to draw a reasonable conclusion from other facts. So take the classic slip and fall case, a hazard, maybe a spill on the floor temporarily. What specific specialized proof requirement does the plaintiff have to meet there?
They absolutely must prove constructive notice.
It's constructive notice, okay.
Yeah. And the general rule basically requires the plaintiff to prove that the dangerous condition, the spill, the puddle, whatever it is, that it existed long enough. So that the defendant, if they were using reasonable care, should have discovered it and remedied it.
So not actual knowledge, but they should have known.
Exactly. They might not have actually known. But enough time passed that reasonable care means they should have. The jury have to be able to infer that crucial element of duration. Time is key.
That sounds like a pretty high bar, almost protective of businesses, maybe. Let's look at the contrast between Goddard v. Boston and MR Co. and the opposite result in Anjou v. Boston Elevated Railway Co. This isn't just about 2 banana peels, right? It's a lesson in how one tiny circumstantial detail can change everything.
It absolutely is.
We'll start with the failure. Goddard, what are the legally dispositive facts here?
Okay, Goddard facts. Plaintiff slips on a banana skin. It's on the floor of a railroad platform. The only evidence presented: the fall itself and where the peel was. Crucially, there was 0 evidence about how long that peel had been there. None.
And what was the core legal issue the Goddard court had to grapple with regarding proof of breach?
The issue was, did just the presence of the banana skin, with absolutely no evidence about how long it was there, allow a reasonable jury to infer the defendant breached its duty of care? Could they make that leap?
What rule did the court use, maybe implicitly, about the time frame needed for constructive notice? Can you state the full rule and break down its testable elements for us?
Sure. The rule is, to prove breach using constructive notice, the plaintiff must present evidence that allows a reasonable inference that the dangerous condition existed long enough for the defendant to have found it through reasonable care.
Okay.
We can break this down into 3 essential elements. 1, a dangerous condition exists. 2, it existed for a considerable period of time. And 3, the defendant failed to discover or remove it during that time.
Thank you. That's clear. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply that second element, the existence for a considerable period of time, in Goddard?
All right, the analysis of element 2, duration. The court basically said the evidence was missing, completely absent. That banana skin. It might have been dropped just a minute before by someone getting off a train. Since there was no factual basis, no description of the peel, how old it looked, nothing the jury would have to just guess. Pure speculation, the court called it, not a reasonable inference. So element 2 failed, flat out.
And if element 2 fails, the whole constructive notice claim fails?
That's right.
It almost sounds like Goddard is saying winning a slip and fall is impossible unless, the defendant confesses.
It can feel that way sometimes.
So how does the analysis change when we look at the facts of Anjou? The plaintiff did get to the jury What were the facts in Anjou?
Okay, undue facts. Plaintiff also falls on a banana peel, also on a railroad platform. But here's the critical difference. Witnesses testified the peel was flattened down, black in color, and gritty.
Ah, the description.
Exactly. That physical description, that decay, is the key circumstantial evidence that makes Anjou different from Godard.
So, after analyzing all the elements with this new evidence about the peel's condition, what was the court's final conclusion in Anjou?
The conclusion was, the appearance and condition, black, flattened, gritty, did permit the inference that it had been there for a considerable period of time.
It looked old.
It looks old.
Yeah.
And that established constructive notice. Essentially, the physical decay of the evidence became a substitute, a proxy, for proving the necessary duration. That was enough to let the case go to the jury.
That distinction is just fascinating, fresh versus rotten evidence being the deciding factor legally. But I understand some courts have kind of moved beyond the notice requirement in certain situations. What's this mode of operation rule, and how does it connect to a case like, say, Jasco, VFW, Woolworth Co.?
We're at the mode of operation rule. Some jurisdictions say, look, if the defendant's whole way of doing business, like in Jasco, selling pizza slices on slippery paper wrappers for people to eat while walking around the store, if that system creates a foreseeable and continuous risk of harm, then the plaintiff doesn't need to prove notice of the specific piece of pizza on the floor.
Interesting. So the system itself is the problem.
Exactly. In Jasco, the court basically said, if you sell pizza like that, drop food and greasy spots are inevitable. They're going to happen. So liability isn't based on failing to find that specific slice, but on the whole, business model being unreasonable in the first place. Notice becomes irrelevant.
Okay, now here's where proving the seemingly unprovable gets really interesting, I think. We're moving from inferring duration, like with constructive notice, to inferring negligence itself. What exactly is res ipsa loquitur, RIL, and what does a plaintiff need to show to use it?
RIL, it literally means the thing speaks for itself. It's a very special kind of circumstantial evidence. It allows the jury to infer the defendant acted unreasonably without any specific proof of what they did wrong.
No specific act needed.
Correct. It's used when the accident itself is just so unusual, so out of the ordinary, that it simply shouldn't happen unless someone was careless. The accident itself points towards negligence.
Okay, so what are the traditional elements? What does the plaintiff have to establish?
Traditionally, the plaintiff needs to show three things, more likely than not. First, the event is the kind of thing that ordinarily does not occur unless someone was negligent. We call this the probability of negligence element.
Okay.
Second, the thing that caused the harm, the instrumentality, was under the exclusive control of the defendant, or at least the defendant was probably the one responsible.
Control. Got it.
And third, there was an absence of voluntary action or contribution by the plaintiff that could have caused it.
Makes sense. Let's unpack this with the case that started it all, right? Byrne v. Bodel. First, what are the legally dispositive facts?
Okay, Byrne facts. The plaintiff is just walking down the street past the defendant's warehouse. Suddenly, a barrel of flour falls out of a window above and hits him. Serious injuries.
Ouch.
Yeah. And neither the plaintiff nor anyone else actually saw the specific mistake, the specific act of carelessness that caused the barrel to fall.
So what was the core legal issue that Chief Baron Pollock had to decide back then?
The issue was, can the mere fact that a heavy barrel of flour falls out of a warehouse window with no other evidence of carelessness be enough to establish an inference of negligence against the owner of the warehouse?
And what rule of law did the court apply? This is where REL comes from, right?
Yeah.
Can you state the rule and break down its elements as they applied it here?
Exactly. This is the birthplace of RIL. The rule essentially is, an inference of negligence is allowed when an accident happens that usually doesn't occur without negligence, and the thing causing the harm is connected to the defendant. The key elements they looked at were, 1, the harm-causing event was probably due to negligence, and 2, the defendant was probably the culpable party.
Thank you. Now for the court's elemental analysis. Let's walk through it. How did the court apply that first element? The event is of a kind that ordinarily does not occur in the absence of negligence. The probability part.
Analysis of element 1, probability of negligence. Well, Chief Baron Pollock had that famous line, right? He basically said, a barrel could not roll out of a warehouse without some negligence.
Pretty straightforward.
Yeah, it's almost common sense. A barrel falling from a window isn't, a natural event like rain. It strongly suggested carelessness was involved. So the event itself screamed negligence, meeting that probability requirement.
Understood. Now, what about the second element? Defendant was probably the culpable party. the control element.
Analysis of element 2. Control. The barrel was falling from the defendant's premises. That location was clearly under the defendant's management and control. The court thought it was, frankly, absurd to require the poor plaintiff, who just got hit by a barrel, to go into the defendant's warehouse and find the specific employee who messed up.
Yeah, that seems fair.
So they implicitly tied the instrumentality, the barrel, to the defendant's control because of where it came from.
And so, after analyzing both those elements, what was the court's final conclusion?
The conclusion was groundbreaking. The court allowed the jury to infer negligence purely from the accident itself. They essentially invented res ipsa loquitur on the spot, establishing that sometimes you just don't need specific proof of the negligent act. The circumstances speak for themselves.
That analysis on probability is really crucial, isn't it? It's the difference between, say, early aviation where crashes were common, maybe not always due to negligence, and something truly bizarre like a falling barrel. What's the standard for proving probably negligence? And how does that contrast with a failure case, like the chair thrown from the hotel in Larson v. St. Francis Hotel?
Right, the analysis of element 1, probability and control liberalization.
Yeah.
The standard isn't that the plaintiff has to rule out every other possible cause. Not at all. The standard is just that a reasonable jury must be able to find that the likely cause was negligence.
Likely cause.
Likely cause. More probable than not. That's why, RIL often applies to things like exploding soda bottles or surgical instruments left inside a patient. But it fails when the defendant clearly didn't have the necessary control.
Like the hotel chair.
Exactly like Larson. RIL is correctly denied there. A pedestrian on the street gets hit by an armchair thrown out of a hotel window during VJ Day celebrations. The hotel argued, look, we don't control what guests do in their rooms with the furniture.
Makes sense.
And the court agreed. The hotel lacked control over the instrumentality of the chair once it was in the guest's hands. Applying RIL there would be unreasonable. It would imply the hotel needed a guard in every room, which is just not feasible.
Yeah.
So the control element failed.
Okay, now we get to what feels like the absolute limit, the outer edge of this doctrine. Traditionally, RIL helps the plaintiff when they can't identify the specific act of negligence, right? But usually they still need to point to the specific party who was negligent.
Generally.
But in Ybarra v. Spangard, the California Supreme Court seemed, willing to bend those rules quite a bit. Let's break down this really controversial case. First, what are the legally dispositive facts?
All right, Ybarra facts. The plaintiff goes in for an appendectomy. He's put under general anesthesia. He wakes up, and he has this severe pain and eventually paralysis in his shoulder and arm, an area totally unrelated to the appendix surgery. So he sues everyone involved. The surgeon, the assisting doctors, the anesthesiologist, the nurses, the hospital owner, everyone who had any control over his body or the instruments while he was unconscious. And he admits up front, I have no idea who specifically injured me or how it happened.
So what was the core legal issue? The defendants moved for non-suit, right? They argued RIL couldn't possibly apply to a whole group like that.
Exactly.
Yeah.
The issue was, can RIL be used against multiple defendants who had successive but not simultaneous control over the plaintiff's unconscious body and the medical tools, even though the injury might have been caused by the negligence of only one specific person in that group?
That's a tough question. What rule of law did the court end up applying? It feels like they had to create or really stretch a rule here, especially relaxing that control element in this unique medical situation.
They certainly stretched it. You can call it the rule, the Ybarra exception. Where a patient is unconscious during medical treatment and an injury occurs to a healthy part of the body unrelated to the operation, RIL can be applied against all defendants who had control over the patient or the instrumentalities during that period.
And the reasoning?
The reasoning was based on a few key factors. 1, the injury happened while the patient was unconscious. 2, it was to a healthy, non-operative area. 3, the defendants were acting as a coordinated medical team. And critically, 4, the defendants had superior, really exclusive access to the information about what actually happened. The patient couldn't possibly know.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court justify relaxing that second element, control of the instrumentality, so much? I mean, responsibility was clearly divided among the team members.
Yeah, the analysis of element 2, control relaxation. The court was really swayed by the policy implications here. The crucial fact was that the plaintiff was rendered unconscious by the defendants themselves.
Okay.
They put him in that vulnerable position.
Right.
And because they acted as this coordinated unit, this team, the court felt it was fair to treat them collectively for RIL purposes. It didn't matter that control shifted from, say, the anesthesiologist to the surgeon to the nurse. The court essentially said, you all had a piece of this. You were all part of the system that injured him while he was helpless.
So it's less about exclusive control and more about collective responsibility in that specific context.
Precisely. And the court reasoned that applying RIL to everyone would force them, the ones with the information, to come forward and explain what happened. This is often called the smoking out function of RIL.
Understood. Now let's talk about that policy or the effect. Why was the court willing to be so creative here, to stretch RIL so far beyond how it was used in, say, burn?
Policy-wise, the court was deeply concerned about what's sometimes called the conspiracy of silence in medicine. The fear was that the medical team, acting together, might protect each other, and none of them would testify about who made the mistake.
Leaving the innocent, injured patient with no remedy.
Exactly. An information vacuum. So RIL here wasn't just about inferring negligence. It was used very deliberately as a procedural tool, a lever, to compel the defendants, the only ones who knew anything, to actually disclose the evidence. The court felt it was profoundly unfair to let the plaintiff lose just because the defendants knocked him out and then wouldn't talk.
And after analyzing all the elements in this very unique way, what was the court's final conclusion?
The conclusion was that RIL did apply to all the defendants. This shifted the practical burden, not the legal burden of proof, but the practical burden of coming forward with evidence onto them. They had to explain themselves or risk liability. While Ybarra is definitely controversial and usually limited to its very specific facts, it's a powerful illustration of RIL being used as an evidentiary tool to ensure fairness when the patient is completely vulnerable and the defendants control all the information.
Okay, so we've broken down constructive notice, we've broken down res ipsa loquitur, we've seen how tiny facts, the color of a banana peel, who controlled a barrel, whether a patient was conscious, can completely flip a legal outcome. For the listener, maybe someone facing a torts exam, how should they structure their analysis when they see a potential breach issue, but there's no direct proof?
Right, you absolutely need a diagnostic checklist, a systematic approach. So, when you're faced with a negligence fact pattern and specific proof of breach is missing, here's how you should probably walk through it. Step 1, direct evidence check. First, just double check, is there any eyewitness testimony?
Yeah?
Any video? If yes, great. You just apply the regular HANDA formula or reasonable person standard directly to that evidence. Easy enough.
Okay, if no direct evidence.
Step 2, circumstantial evidence notice check. If there's no direct proof, and the case looks like a slip and fall or a premises liability issue with a temporary condition, your next thought must be constructive notice.
And look for the details.
Yes. Hunt for facts describing the condition. Is it old, decayed, mashed, gritty, widespread? Anything that implies it was there for a while. That's your duration evidence. But if the facts suggest the business model itself is inherently risky, like self-service food, bulk bins, that kind of thing, immediately pivot. Consider the mode of operation exception. If it applies, you argue notice is irrelevant.
Got it. Notice first, unless mode of operation fits. What if it's not a slip and fall? What if it's just a weird accident?
Step 3, res ipsa loquitur, RIL. Check. If the accident seems highly unusual, the kind of thing that screams someone messed up, then you absolutely must check for RIL. Go through the elements systematically. First, element 1, probability. Ask yourself, is this the type of accident that normally doesn't happen without negligence? Think falling barrels, exploding bottles, surgical tools left behind. Is it probably negligence?
Yeah.
Second, element 2, control responsibility. Was the defendant probably the culpable party? Did they likely have control over the thing that caused the harm? Remember the Larson chair problem. Avoid situations where control is clearly lost. But also remember, control has been liberalized. It's often about probable responsibility now. And don't forget the very specific Ybarra exception for unconscious patients and medical teams.
Right, the narrow exception.
Third, element 3, plaintiff contribution. Briefly consider, did the plaintiff do anything to cause their own harm? This is less critical now with comparative fault, but it can still be relevant to figuring out if the defendant was truly the responsible party under element 2.
Okay, check probability, control, and plaintiff's role. Then what?
Step 4, RIL effect. If and only if all the RIL elements are met, remember what it actually does. In most places, it means the jury is permitted to infer negligence.
Permitted, not required.
Exactly. It doesn't guarantee a win for the plaintiff. It just means their case is strong enough, circumstantially, to get past a directed verdict motion and let the jury decide. It gets them their day in court on the breach issue.
That structured approach, direct proof, fail check, notice mode of operation, R check, RIL elements, understand RIL effect, that's incredibly helpful.
Yeah.
It really highlights how the law tries to deal with this inherent difficulty of, well, proving a negative, proving someone failed to be careful when you didn't see it happen.
Precisely. These doctrines, constructive notice and RIL, they really show the law trying to strike that delicate balance. You want to compensate injured plaintiffs, but you also need to protect defendants from being held liable based on nothing more than guesswork or speculation.
It's a fascinating tension. Okay, let's leave our listeners with something to think about, a provocative thought. We talked about how a key policy justification for RIL, especially in a case like Ibarra, is this smoking out function, forcing disclosure information that only the defendant has.
Right.
But now, think about modern civil procedure. We have incredibly broad pretrial discovery tools, depositions, interrogatories, requests for documents. So the question is, does the original NOI for RIL as an information forcing device, and maybe the judicial stretching we saw in Ybarra, does it still make sense today? Or perhaps, should courts be tougher? Should RIL be denied if it seems like the plaintiff just didn't do a thorough enough investigation using the discovery tools they already have available? Where should that line be drawn now? Something for you to consider.